All right. Next case. You, sir. Step forward. You, ma'am. Take your place at the podium. State your name for the record. My name is Robert Jenkins, Your Honor. And you, ma'am. Patricia Miller, Your Honor. All right, Mr. Jenkins. What is your claim today? Speak clearly. Don't mumble, Your Honor. I'm here because Miss Miller here. She owes me $500 for a broken window. A broken window. And how exactly did this window get broken, Mr. Jenkins? Well, Your Honor, it was like this. Miss Miller, she lives next door to me, and she has this dog, a beagle, a real noisy dog actually. Irrelevant. Stick to the facts. The window. Right. The dog. He's always barking and running round all over her yard, and sometimes my yard. She lets him loose all the time, and he dug up my prize-winning petunias last month. Again, irrelevant. The window. How did the dog break your window? He didn't break it directly, Your Honor. Not directly. But he caused it. He chased a squirrel into my yard. And then, well, he ran right into my garage door. And that scared me. So I jumped. And I dropped my hammer. And it hit my window. The garage window. So the dog didn't break the window. You broke the window by dropping your hammer. But it was because of the dog, Your Honor. He startled me. If he hadn't been there, chasing that squirrel, my window would be fine. My $500 window. Miss Miller, what do you have to say about this? Is your dog a menace? Does he roam free, destroying property, scaring your neighbors into dropping their tools? Your Honor, this is ridiculous. My dog, Buster, he's a sweet dog, a beagle. He loves to play. And yes, he chases squirrels. That's what dogs do. It's natural. He was in my yard. Or maybe he crossed the property line for a moment. But he didn't touch Mr. Jenkins. He didn't break anything. Mr. Jenkins. He's just clumsy. And he blames everyone else for his own mistakes. Clumsy. Is that your defense, Miss Miller? That Mr. Jenkins is clumsy, and that your dog's natural instincts absolve you of responsibility? Your Honor, I try to keep Buster in my yard. I really do. I have a fence. It's not a perfect fence, but it's there. And Buster, he squeezes under it, or jumps over it, when he sees something interesting, like a squirrel. But I always call him back, and he comes back. Mr. Jenkins, did you try to mitigate your damages? Did you try to catch the dog, or avoid dropping the hammer? I was startled, Your Honor. It happened so fast. 1 minute I'm panning a shelf, the next, a blur of brown and white, and a loud bark right by my ear. It was a big scare. And the hammer, it slipped. A $500 window. Is that a fair price for the repair, Mr. Jenkins? Do you have an estimate? Yes, Your Honor. Here it is. From Henderson Glass, $523.47. I'm just asking for $500. Miss Miller, do you dispute the cost of the repair? I don't know the cost, Your Honor, because I don't believe I'm responsible for it. My dog, he didn't break the window. He didn't even touch the man. So you're saying a dog running across the yard, startling a neighbor, who then drops a hammer, breaking a window, is not your responsibility, even though your dog was off your property? event for a moment and caused a chain of events. It was an accident, Your Honor. A freak accident. And Mr. Jenkins. He needs to pay more attention. He can't blame my dog for his own clumsiness. This isn't about clumsiness, Miss Miller. This is about responsibility. You own a dog. You are responsible for that dog's actions, especially when those actions impact your neighbors, whether directly or indirectly. The law is very clear on animal control and property damage, even if it's a chain reaction. The initial cause is often the key. Mr. Jenkins, do you have any other evidence besides your testimony and the estimate? No, Your Honor, just my word and the broken window. And you, Miss Miller, any witnesses to this alleged clumsiness? No, Your Honor, just me and Buster. And he can't talk. That's quite apparent, Miss Miller. Let me tell you something about common sense and responsibility. When you own an animal, you are responsible for its behavior. You have a duty to ensure your animal does not cause harm or damage to others or their property, even if it's not a direct bite or a direct scratch. If your animal's actions lead to a consequence, you are accountable. In this case, your dog, Buster, regardless of his sweet nature or his natural instincts, was off your property, and his actions, chasing a squirrel, led directly to Mr. Jenkins being startled, and subsequently dropping his hammer, breaking his window. This is a clear chain of causation. Your defense that Mr. Jenkins is clumsy, or that it was a freak accident, holds no water with this court. You are responsible for your dog and his roaming, and the consequences that follow. I find in favor of the plaintiff, Mr. Jenkins. Miss Miller, you owe Mr. Jenkins $500. Case closed. My name is Kevin Thompson, Your Honor. And you, ma'am. My name is Sarah Davis, Your Honor. All right, Mr. Thompson. What is your claim today, Your Honor? I'm here because Ms. Davis here. She sold me a car, a used car, and she said it was in perfect condition. But it's not. It's a lemon. I want my money back. $2,000. A lemon. Is that right? And when did you buy this car? 2 weeks ago, Your Honor. A 2005 Honda Civic. She had an ad online. Said it was well maintained. A great car. And I needed a car for my new job. I gave her the cash right there. $2,000. Ms. Davis, did you sell this car to Mr. Thompson? Yes, Your Honor. I did. And did you tell him it was in perfect condition? Well, Your Honor, I said it was a good car for its age. I didn't say it was perfect. I mean, it's the 20-year-old car. What does he expect? It ran fine for me. Never had a problem with it. I told him it was a good little car. Reliable. Mr. Thompson, what exactly is wrong with the car? Everything, Your Honor. Everything. The engine light came on the very next day. And the transmission is slipping. The air conditioning doesn't work. And the brakes. They're soft. I took it to a mechanic. He said it would cost me more than the car is worth to fix it. He said it was a mess. Ms. Davis, did you know about these issues? No, Your Honor. I swear. I didn't. The engine light was never on for me. The air conditioning worked fine last summer. I don't know why it wouldn't now. And the transmission. It was always a little jerky. But I didn't think anything of it. It's an old car. What does he want? A brand new car for $2,000. Mr. Thompson, did you have the car inspected before you bought it? No, Your Honor. She seemed so nice. And it was a good deal. I needed it right away. My first day of work was a Monday, and I bought it on a Friday. I trusted her. She said it was the great car. I took her word for it. Ma'am, did you provide Mr. Thompson with any maintenance records? Any service history? No, Your Honor. I don't keep things like that. I just took it to my local garage for oil changes. They know me. I never had a big problem with it. Mr. Thompson, in the state of New York, a private sale of a used car is sold as is. Did you know that? No, Your Honor. I thought if a seller lies, or doesn't tell you the truth, that you could get your money back. She said it was the great car. That's a lie. Miss Davis, did you tell him there was nothing wrong with the car? I told him it was a good car, a reliable car. I wouldn't lie to him. It was. It was good for me. This is what we call a difference of opinion. One person's good car is another person's lemon. And you, sir, you had the opportunity to have the car inspected. You chose not to. You took the risk. This isn't a case of fraud. It's the case of buyer beware. Miss Davis, she gave you a used car, not a new one. She's not a dealership. She's a private individual. And she's not a mechanic. She's just a person selling her old car. Mr. Thompson, you trusted her word. And that was your mistake. This court is not here to protect you from your own bad decisions. The law is clear. In a private sale, the buyer is responsible for doing their own due diligence. You should have had that car inspected. You should have checked the engine light. You should have driven it more than a few miles before handing over your money. You did none of those things. Your complaint is with yourself, not with Ms. Davis. She sold you a car, and you bought it. The risk was yours, not hers. The moment you handed her the money, you owned that car, with all its problems, known and unknown. I find for the defendant, Ms. Davis, your case is dismissed.